All rise. The Court of Appeals, Division 1 is now in session.
Good morning. You may all be seated. We're here today on our case number 1CACV140739, City of Phoenix versus Glen Air Electronics et al. As you all know, each side is allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like. The clock on the podium will reflect the total amount you have, including what you may have decided to reserve. We record these proceedings, so when you approach the podium, and Ms. O'Grady, both times if you do, please help us by reciting your name in the microphone so that we'll know who it is, and the name of your client or clients or some of them, as the case may be. We have read the briefs and we've studied the record at great length. We've also discussed the case in our conference. So, with that, Mr. Ray, thanks.
Good morning, and may it please the Court. Mary O'Grady, representing Appellant City of Phoenix, and I'm here today with Brad Holm, the Phoenix City Attorney, at council table. We ask the Court to reverse the trial court's decision that dismissed the city's third-party complaints against the developers and the contractors because the statute of repose in 12-552 does not apply to these claims that were brought by the city. Independent of that principle generally that applies to all the claims at issue here, there's a separate issue as to the developers only because their claims fall outside the statute of repose because they aren't based on contract. They're based on the city's permit and the ordinances that govern those city permits. But I wanted to start by talking about the broader issue in terms of the statute of repose and why it doesn't apply to the city's claims in this action based on the common law nullum tempus doctrine and also ARS 12510 that precludes limitations on actions against the city. These are, long-standing doctrines that have been part of our law from before statehood, but certainly recognized as precluding time running against cities since the City of Bisbee case in 1938. The common law doctrine exists. It was codified in part by 12510, but it still exists independent of that statute. If the legislature wants to override that doctrine, it needs to specifically and expressly do so in statute. And they have not done so in 552, the statute of repose.
Mr. Grady, there are a host of cases over time that use different verbs and adverbs in describing how specific the legislature needs to be when it wants to overrule that doctrine. How do we know which verb or adverb combination to choose when we're testing a statute?
Well, I think they've been consistent in the principle that it has to be specific in terms of applying that limitation to a governmental entity. So it's the specificity that matters. There is also the language that it can be necessarily implied by the statutory language. And the case law concerning what it means to be necessarily implied says that that has to be the only possible interpretation. And that's not true here. There's other possible interpretations, which is the interpretation the city has advocated in this case, because the statute still works on its face. It works as a statute of general application in terms of a statute of repose. It simply doesn't apply to governmental claims because it doesn't say it applies to governmental claims, and that's what it needs to do to override the nullum tempus doctrine.
But what does the notwithstanding provision bring to us then?
Your Honor, the notwithstanding provision, a few points regarding the notwithstanding provision. One, it's notwithstanding any other statute, which is different than a lot of the notwithstanding clauses you'll see in Arizona law, and different than this notwithstanding clause in State v. Pereira, which is one of the main cases that appellees rely on. So that by its terms does not override the common law. It just refers to other statutes. It also lacks the specificity that's required. It converts that to a statute of general application, but it's not enough to override the common law doctrine of nullum tempus. And when you look back at 12510, what you end up with is a statute. When you look at 12510, by its terms, the only exception that's provided is for 529. There's no exception for the statute of repose in that statute. So to harmonize these two statutes, you look to the nullum tempus doctrine that survives and exists independent of the statutes, and also the principle of statutory construction that's related to the nullum tempus doctrine, but it's not limited to timeframes. And that establishes the same principle that if you're dealing with a statute of general application, you have to figure out if it applies to a governmental entity, you have to look for some specific reference to the governmental entity. And that's like the Webb case is an example of that, the old mechanics lien case that applies that more general statutory construction principle. So when you look at 510, where there's no specific exception for the statute of repose in 552, and you look at 552 that has does not override the common law doctrine of nullum tempus, and you apply the principles of statutory construction that you have to have a specific provision referring to a governmental entity to apply those limitations to the government, you end up having 510 controls, nullum tempus controls, and the statute of repose does not apply to the governmental entities.
Is the Webb case your best case for the proposition that when you're talking about a statute that excludes or accepts government entities, it needs to make specific reference to the government entity?
Your Honor, I think let me see if it's the best case. It's a strong case in terms of I think Webb is an important case to review because that's not a state, that's a case that applies this general doctrine of statutory construction that it has to be specific, and it's not limited to the nullum tempus doctrine. It's related, but it's not limited in that way. City of Bisbee obviously is an important case, and that's the other, I think, main case. And then there are cases in the 90s and in the 80s that still apply the doctrine, but I think City of Bisbee, those anchoring cases are really the best cases that apply this doctrine. I know that the appellees rely on the Albano case, but that's not a nullum tempus case. That's not a case that addresses these principles at all. So it's really this other line of cases that affect when does a city's claim, when does the city have a claim, this doctrine that's limitations of periods of time don't run against the city, and they need to be specific. And the principle that the courts are concerned about and the common law doctrine's concerned about is protecting the public fisc, protecting the public interest, and so they have these requirements that the times don't run because they want to protect, again, the public's right to recover monies for the public fisc, right to take actions in the public interest. And they want to make sure that if the legislature intends to limit those rights, they do so with specificity, and so not by these statutes of general application. That's what those statutory provisions stand for, those cases stand for. So when you look at 12510, again, there you have a preservation of the common law doctrine, and also no specific exception for 510. And for those reasons, the statute of repose does not apply to the city's claims here. Now, I know in addition to relying on the Albano case, there's a reference to the legislative history here, and particularly the 1992 legislative history. And on that point, again, I think it's the language of the statutes that mean the most in terms of did they specifically and expressly say that the statute of repose, applies to the cities, and they didn't. And then the legislative history that matters is the 1989 legislative history when they approved this statute.
But they also approved the language of the statute, did they not?
Absolutely, Your
So
Honor.
we've got 510 that's 90 years older than 552, and in 552 they say, notwithstanding any other statute, this is the way we're going to do this, but you're saying 510 still is carved out of that?
Yes, Your Honor, because when you look at, well, for two reasons. One, in addition to 510, you have the common law doctrine that is absolutely not overridden by this language that says notwithstanding any other statute.
A common law doctrine is a common law doctrine. I mean, we hold that up with a certain degree of awe. But at the same time, if the legislature passes a statute and says, look, we used to tell you to look to 510, don't look to 510 anymore. On this issue, you look to 552 because it says notwithstanding any other statute. What do I have that says that's not what the legislature was intending?
You have 12510 still that has no exception for 552, which they did, for example, with 529. They knew how to carve out an exception from that general principle by putting it in that statute. Or they could have put it in 552, something that says this applies to actions by government. But they didn't. They need to be a specific reference to that, again, for the purposes explained in the cases that they don't want the legislature to they want to make sure the legislature is specifically considering claims that would be brought by public entities before they apply statutes of general application to governmental claims. And I think the difference between statute and law is important because a lot of the notwithstanding clauses do use broader language than the legislature chose to use in this circumstance. And go ahead.
Finish your sentence. I'm sorry.
Well, I was going to go on with the legislative history discussion.
I'd like to ask you to make sure you talk about the permit ordinance issue as to the developers. And I'd like at some point to understand exactly what the link is. As I understand it, it's from the permit, which requires the permittee to perform all work in accordance with the plans and provisions which themselves incorporate the ordinances. And we see an indemnity obligation in Code Section 31-40. Is that the link, or is there a more precise way to describe the link to the indemnity obligations of the developers in the mind of the city?
The indemnity obligation is based on the local ordinance. That is a condition. If you get a permit, you're subject to these indemnification requirements by local ordinance. So it's important in this context because the 552, the statute of repose, only applies to claims based on contract. Right. And there is no contract with the developers. There's only this city-issued permit and then the local laws that govern the conditions that are related to that permit, one of which is this obligation to indemnify. And that's why the developer claims, separate and apart from the issues of nullum tempus and 510, the developer's claims aren't within 552. And so those should be reinstated. The court was in error to dismiss those claims, independent of the other issues that the city has raised.
It just seems, I mean, maybe this question is better asked of the other side, but what if the ordinance had said all permittees must indemnify the city, as opposed to say that the permittees agree? I mean, is your argument it's an obligation, it's a take it or leave it condition?
That's right, Your Honor. It's an obligation. By operation of law, you get a permit. These are the terms. It's by operation of local ordinance. And so whether it says agrees or whether it says permittee indemnifies, what matters here is it doesn't arise by contract. It arises by operation of law because of the ordinance and because of the conditions that apply to any permit that's issued. And unless there are further questions on these issues, we briefed also the attorney fees issue. I didn't intend to address that unless there are specific questions. And I will reserve remaining time for rebuttal. Unless there are further questions, Your Honor.
Thanks.
No, I'm good. Thank you.
Okay, thank you.
May it please the court, my name is Kevin O'Malley, and I'll be presenting the lead argument on behalf of all of the appellees. The first question is, does the construction statute of repose 552 apply to the city? The answer to that, I submit, is yes, for three reasons. The statutory language that was mentioned a minute ago, the legislative history in 1992 is very clear, and the underlying public policy as laid out for us by the Supreme Court in Albano all lead to that conclusion. The statute says notwithstanding any other statute. That's the way the legislature communicates, to respond to your question, Judge Jones, that's the way the legislature communicates that 510 no longer applies. It's in the same chapter. And it said notwithstanding any other statute. The legislative history in the 1992 amendments is, of course, very insightful because it's dealing with the precise problem we're addressing here today, which is, does it apply to a government entity? That's why they amended the statute in 1992, because of a problem dealing with a claim by a government entity. In their brief, they would suggest to you that you ought to indulge the presumption that in the 1992 amendments, the legislature ignored nullum tempus, forgot about 510. The presumption that this court indulges is exactly the opposite. We assume that the legislature knew about nullum tempus and 510 when they passed the amendment in 1992. And the legislative intent is clear that it applies in this situation because Albano tells us the history, the purpose, and the way in which statutes of repose differ from statutes of limitation. It is a fundamental distinction. That's why our Supreme Court talked about statute of repose as being an immunity from suit, as being an extinguishment of a claim, because it's markedly different than a statute of limitations, which is what the nullum tempus doctrine is all about. It's what 510 is all about.
Does your argument under Albano, is that an independent ground for holding that the statute doesn't apply to the city, separate and apart from 510, actually? I mean, because if a statute of repose is different from a limitations period, then I guess your argument would be that 510 doesn't apply either.
Right. It's actually, if you think about it this way, Judge, Albano was a more difficult case for the court because the notwithstanding any other statute language didn't expressly address the common law doctrine. Yeah. So the Supreme Court was wrestling with a more difficult problem. And it said, because of the nature of a statute of repose, it is intended, the legislator made it very clear, to drop a curtain, to end liability. Why? Because the legislative history in 1989, not just 1992, in 1989 said, why are we doing this? Because they identified a crisis in the construction industry, skyrocketing insurance claims, and all of that. And that's why there's a difference between the statute of repose and statute of limitations. So the Supreme Court said, even though this statute doesn't say notwithstanding any other law to encompass everything, the purpose of the statute of repose actually trumps common law doctrines. It goes on to tell you specifically that not only are you not allowed, not only is the court not allowed, it's not a judicial function to create exceptions to the statute of repose, no common law doctrine is allowed to survive. Even though the Supreme Court recognized that there were good public policy grounds underlying tolling the statute of limitations on a pending class action, they said it's not the judicial function. And so they said explicitly, if the legislature wants to create an exception to 552, this immutable end of all claims, this extinguishment of all claims, then the legislature needs to do that. And does the legislature know how to do that? Yes, they do. We know that because if you look at the Purchaser Dwelling Act, for example, that controls created and controls a pre-suit process in the construction industry for homeowners to make claims. The legislature recognized in that statute, look, we're going to have a time period here, pre-suit, that you're going to have to go through. So they said, don't want the homeowners to lose their claims. So what did they do? They said explicitly in the statute of limitations and the construction statute of repose, section 552, are told during that process. So Albano, Supreme Court tells us and tells you today, that's for the legislature to do, They've done it. They know how to do it. And we cannot indulge some suggestion that the legislature in 1989 and 1992 did not know about Nullum Tempus and 510, which is in the same chapter. So let's talk a little bit. Let me just give you an example of why I think this works. We cited the Pariah case. The facts of the Pariah case, I think, are very helpful to us. In Pariah, the defendant was arrested for having drugs within 59 feet of a school. There was a statute that said you have an enhanced penalty for that. If you're guilty of having drugs near our children in a school, you have to go to jail. Makes sense, good public policy. But there was another statute emanating from a referendum that adopted a different public policy. It said any drug possession case, the defendant is entitled to probation and diversion. So what do? This court resolved that by saying, look, there's good public policy, just as there is under Nullum Tempus, but the legislature has spoken. And it said, notwithstanding any other statute, and therefore, that the defendant had to be given probation. They could not get the enhanced sentence. That's how that statute operates. The very purpose of a statute of repose, the very purpose of it, is to trump limitations of actions. That's what the purpose is, because otherwise every other claim is already governed by some kind of a statute of limitation. So that's why Albano speaks of immunity and extinguishment. That's why our federal district courts have said, in both Warfield and Olson, that even the federal government, not bound by statute of limitations, but they're bound by Arizona statutes of repose. Even the federal government is.
What's the best, getting away from Albano and that analysis, getting back to the relationship between 510 and 552, what cases should we look to figure out whether, notwithstanding any other statute, is sufficient enough to indicate an intent to trump the city government's right to be immune?
I think, Your Honor, a couple of things. One is that notwithstanding language is specifically addressed to occupy the field. That is the best way, and this court has said it in multiple cases. That's the best way for the legislature to tell you that we don't care what other statute's out there. That's the best way. And then Albano comes in to clean up the common law, saying the common law doctrine can't apply to avoid or be an exception to the statute either. And if you look at it, Your Honor, they said their best case, two cases. Best is Bisbee and Webb. Let's talk about Bisbee for a second. If you actually dig down into Bisbee, what does Bisbee really say? It says we're going to first of all look at this in the context of modern public policy. All right? What's the modern public policy here? The modern public policy is that the city of Phoenix should be responsible for its own negligence. That's what it's suing us for in indemnity. We abolished sovereign immunity years ago. What's the public policy with regard to this specific issue? 34226 tells us that the city is prohibited from demanding indemnity from someone else in a construction contract. That's the public policy. The public policy under 552 is that our clients should be immune from claims that are 46 years old. Those are the three public policies that are at issue here. So what does Bisbee go on to say? Bisbee goes on to say, look at, when we're talking about the statute of limitations and the nullus tempus doctrine, what we're talking about is two things. It does not extinguish, the statute of limitations does not extinguish the right. It extinguishes only the remedy. And the remedy should not be lost because of the negligence of a public official. That's what Bisbee says. I submit to you that Bisbee foreshadowed Albano. Because Albano comes in some 50 years later and says, you know what? Yeah, that's an important distinction that Bisbee recognized. Because the statute of repose extinguishes the right. It extinguishes the cause of action. And likewise, the statute of repose could care less about whether someone was diligent or not diligent in bringing the claim. That's not what drove the legislature to adopt this. So the policy reasons The analysis of Bisbee as to the difference between a statute of repose and a statute of limitations, all of that supports our argument. Secondly, on Webb. In Webb, they don't cite you any cases that deal with, well, notwithstanding any other statute, it's not good enough. I think, Judge Jones, you're right. How else do you say it? But they don't cite you any cases. They say Webb. Well, what's Webb really about? The court delved down. The court's not, it has to understand the real issues they're dealing with. The court delved down into that and said, look, it makes no sense to allow a general lien statute to apply to a government building. Why? Because for one thing, it would give a right that's unenforceable. You can't foreclose on a public building simply because you provided materials to it. And likewise, there's a recognition that the financing mechanisms in these public contracts, bonds and so forth, they deal with the issue of how people get paid in those projects. So the court used its common sense to say, look, at this general statute over here makes no sense when you're dealing with a public project. But this case deals with notwithstanding. Go ahead, Your Honor.
So talk to us about why the permit establishes a contract right.
Just where I was going to go. Thank you, Your Honor. Question is this agreement to indemnify, an agreement within Section 552? Look, we have no quarrel with the notion that the question of whether to issue a permit or to revoke it is a police power. Of course it is. And there's all kinds of rules that deal with that. Estoppel if you don't give the permit when you should, and if you violate the permit, they revoke it. And there's a regulatory process for that. That's not what we're talking about here. We're talking about the city suing us in order to get the money that they paid the plaintiffs in settlement and to get their attorney's fees back. It's an indemnity lawsuit. In fact, the city's own brief on page 4 characterizes the obligation to indemnify as a quote-unquote covenant. That's their language from their brief.
So then is it just the indemnification, the existence of an indemnification agreement, as you like to state, I think, in your briefs, that is the sole universe that's given rise to by the issue of contract in this case?
Well, I think two things. The derivation of it is, to answer your specific question before, and let me tie it into both. One is that the developer agreed to perform in compliance with a set of approved plans. The approved plans incorporated the MAG specs. The MAG specs incorporated the statutes. And the statute says that we agree to indemnify. This isn't a statute that says you shall, you may, the kind of typical thing. You agree to indemnify.
Is that it, though? What if the ordinance said all permittees must indemnify the city?
Which, Your Honor, it raised the question in my mind, why haven't they cited a case? Why haven't they cited a case that says, well, we could just say shall. We could just say may. It's all the same thing.
You must stop at a red light. You must indemnify.
Yeah, and let me tell you two things about that. One, I thought about that in the last couple of days, and the city of Tacoma tried that. They passed an ordinance that attempted to impose an obligation on an abutting landowner to identify the city if, for example, there was a defect in the sidewalk. And if you didn't, you know what the ramification was? The ramification was you had to indemnify the city for that problem, that accident that occurred there. You know what the Supreme Court of Washington said? They said that is not an exercise of police power. That goes way beyond the police power that's involved in a permit or a license or whatever. It's unenforceable as going beyond the permissible scope. It's in fact unconstitutional.
And what's that case, or what's that?
Rivet, R-A-V-E-T-T versus City of Tacoma, 770 P. 2nd, 299. And you raised the issue of an example of a driver's license or a permit. When I go get a driver's license from the state of Arizona, I don't agree to obey the laws. I don't have something in my license that says, it's the intent of the state and Kevin O'Malley to abide by the laws. And if I violate the laws, what do? They fine me or they take away my license. They don't sue me. And what if they tried to? What if, for example, in the license, your driver's license, it said, not only that, but you're going to indemnify us. So when you got out in an accident on the roadway, turns out that the accident's caused by a defect in the highway. Would it be a proper exercise of police power to make me indemnify the state simply because they gave me a driver's license? I don't think so. That's why this is all about an agreement. That's why the statute speaks in terms of agreement, and it's incorporated into some plans. And yeah, it's a condition. It's a condition. But, think of it this way. When I get my Visa card, when I get, sign up at Apple or one of those people, they get, as a condition, there's all kinds of things that I agree to. Are those contracts of adhesion? Sure they are. Are they enforceable in Arizona? Yeah, they are. So as a condition, if we want a permit, as a condition, they said to us, you need to agree to indemnify us. And so we did. The city says, well, it's not a Dickard deal. Well, so what? We have lots of contracts that are not Dickard deals.
Is there a quid pro quo in the process of that?
Sure, ultimately, Your Honor, there is, because think about the distinction that they raised before between the contractors and the developers. The city had two ways to go about getting necessary infrastructure built into the city so the city can grow. One was entering into contracts directly with contractors, in which the contractor comes in, subject to a contract with the city, puts in the underground infrastructure. Or they could have done it the way they did with the developers. They give the developers a permit. By the permit, they go in and they put in the infrastructure and ultimately dedicate it to the city. Same thing, same result. So, of course, the city is getting the benefit of water pipes and everything else that it needs to grow. There's a quid pro quo
but
for that.
But not just water pipes. Water pipes built to their specifications and mags, right?
Water pipes built their specification and exactly. And building them to their specifications makes perfect sense. That is a perfectly reasonable thing for anybody in agreement to extract from the other side. But to then say, and in addition to that, you're going to indemnify, you're going to agree to indemnify. Why do they use that language? They use that language because that's the language of an agreement. Just like all of these other obligations that I undertake with Verizon or Apple or anyone else. And so those are, I submit to you, Your Honor, those are language of agreement. It is a condition, as Judge Reyes said, it was a condition, it was an agreement that was collateral to the permit. The permit, if you look at the permit itself, it's signed off as completed years ago. They're not suing for the permit. The word indemnity doesn't appear in the permit. It's nowhere in the permit. It's incorporated of an agreement by us that you have to go through 3 layers of contractual documents to get to.
How does the city generally enforce its construction and permitting ordinances against a developer?
Its actual permit obligations is that there's all kinds of ways in which there's a mechanism, I think, through city court and administrative process where they say, you know what, they go out and their inspectors say that you're not building it to that. They can issue a stop work order. There's a whole body of law and a whole separate mechanism. It isn't in the Superior Court in a claim for indemnity.
I just have this one ordinance section in front of me, 3140. Permit, indemnity, provision, and insurance required. Is the language of the other portions of the ordinances that are incorporated by reference into the permit or the agreement to comply with that order, are those other provisions of the ordinances written in similar language agree, or are they more mandatory?
I think the ones that they enforce by the regulatory process are more mandatory. This one speaks in terms of an agreement, and I think it does because it has to. And by the way, just so the record is clear, this permit, we take the position this permit doesn't even apply to our projects.
Yeah, that's
but
enough.
So be it. If it did, we don't think it's enforceable. So, in conclusion, Your Honor. There is no public policy. There's no public policy that would expand, that would support expanding the city's police power in some general way. We have express indemnity, we have implied indemnity. Of course, implied indemnity doesn't apply here because the city would have to be free of negligence, and if you have an express agreement under INA, that controls anyway. So they want you to create something called police power indemnity. Where do they get that from? There's no cases that suggest that. And why would you? We know that sovereign immunity has been abolished. We know that the current policy in Arizona is that they could not get this indemnity. Why isn't 34226 control here? You know why? Because it was prospective only some 10 years ago. So why are we even here? Because they're suing us about projects that are 30 or 40 years old. That's why we passed the statute of repose, to stop this. And the legislature jumped in at a later time and told them they could never even get indemnity in these circumstances. The Supreme Court has spoken, the legislature has spoken, and their own ordinance incorporated into this permit, their own ordinance speaks in terms of an agreement. It is a contract. 552 was drafted to be as broad as possible to stop these kinds of 30 and 40-year-old claims being brought against us. It doesn't matter. It doesn't speak about person. It doesn't matter who the plaintiff is. That's not the focus of a statute of repose. It's who the defendants are in cutting off liability. Thank you, Your Honor.
Thank you. Ms. O'Grady.
Thank you, Your Honor. Mary O'Grady for the City of Phoenix. I'll start where they left off in terms of the indemnification obligation. This is an indemnification obligation that is a matter of local ordinance, that it is created as a matter of local policy as a condition of getting a city permit. It is not, there's no offer, acceptance, consideration contract between the city and the developers. They are permittees, subject to the requirements of local ordinance. Now, all the other kind of issues that have been raised about whether the city can do this or not do this, strikes me that if they want to challenge those are potentially remand issues, because here the statute of repose does not apply, only applies to things based on contract, and this isn't. This is based on the local ordinance adopted by the City of Phoenix to govern the requirements of any of permittees. So that's not within the statute of repose. And if they
know whether the question I asked Mr. O'Malley or talked about with him is, do you happen to know whether other mandatory obligations of a developer under a permit are stated in the code in some other fashion as opposed to permittee agrees?
Off the top of my head, Your Honor, I don't know of other examples.
We'll take a look.
But this is clearly a local ordinance establishing local policy that governs permits, and we are, the city is trying to enforce that local ordinance by bringing this indemnification action. It is outside the scope of the statute of repose. On the broader question of the application of the statute 552 to the cities, again, on the books now we have 510 that if you read just 510, nothing in Chapter 5 applies to it by its terms. You read 552, you have the notwithstanding any other statute. And then you read the case law, and we have a common law doctrine, plus statutory tools of interpretation that say you got to be specific if you're trying to abolish claims of the city for public policy reasons that are important, to protect the public interest, to protect the public fisc. And we agree it's up to the legislature. And the cases in this area tell the legislature how to proceed. And they didn't do that here. They didn't do it in 89, and they didn't do it in 92.
But, Mr. Grady, you will agree that 510 does not say notwithstanding any other statute. You say we have 510, we have 552. You do. They've got about 90 years worth of difference between them. And when the younger statute, when 552 was passed, they said, hey, notwithstanding anything else in this this article, this section, the title, excuse me, we are imposing this over the top. Isn't that what that says?
Here's what 510 says. Except as provided in Section 12529, the state, which includes the city, shall not be barred by the limitations of actions provided in this, prescribed in this chapter. So you read 510, nothing in this chapter, which would include 552, applies to this to claims. So then you have the challenge of, okay, I've got 510 and I've got 552. How do I harmonize these statutes? Because there is this broad, notwithstanding any other statute, lead-in language to 552. And the cases that address this issue say you have to look for something specific in the statute that they're trying to apply to the city, to the governmental entity. And that's where the legislature didn't do that. They didn't do it in 89 or not 89. They didn't do it in 92. And in 92, I'll say I didn't really address that issue previously. There you have the Central Arizona Water Conservation District coming to the government, coming to the legislature and saying, we have these huge claims, and there's a motion to dismiss based on this statute of repose, and we're nervous about this, so please change the law to make sure we win our motion. And so they changed the law on that narrow issue. That is them trying to help reduce litigation risk. The 92 legislature, excuse me, Your Honor.
No, but all they did was to basically push back the effective date of the statute of repose, right?
That's right, Your Honor. That was what the legislature did.
Because otherwise, the CWTC, I think that Central Arizona Project, otherwise the statute of repose would have precluded the claims they wanted to make against the developers.
Your Honor, I think they were wrong
On
the law, but
were
here's
wrong about what?
Here's what I think was going on there, and I think what the legislature history says was going on there. The legislature was weighing in to eliminate this litigation risk for CAWCD. It's not up to that legislature to say, here's what we did in 1989. It's not up to that legislature to interpret and declare what the law is. That's up to the courts. So they were, 89. What the legislature did in 89 is up to the courts to interpret. What the legislature did in 92 was not an addressing of the nullum tempus doctrine.
That was, they just want to save CAP the risk.
That was them, limiting risk.
Eliminate any risk.
And CAWCD, we have this problem, we have this big motion to dismiss, we have big claims. They say, okay, here, we'll help you out. And it doesn't say anything broader about the issues here.
Someone must have thought that 552 applied and the statute of repose was going to be a concern.
They did, because there were motions pending on that issue. So they're, again, limiting that risk. It doesn't mean it did apply. And it doesn't mean it did apply. That's the context for 92. And so to harmonize these statutes, the principles that control are those that say, that explain how you determine a statute applies to a governmental entity. We've cited the out-of-state cases, most of which apply the statute of repose, statute of limitations. These same principles apply to both. And the issues in the class action case, the Shea Holmes Albano case, those aren't the issues that are here. That was, how do you harmonize this court rule that's under a different kind of constitutional power versus this recently enacted legislation. Unless there are further questions.
Thank you.
Thank you, Your Honors.
Thank you to both sides for your argument and your good briefing. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.